I'm told that Shamik said is going to be a little late today, so that's the reason why we can't see him here. Let's get going, because this again is a slightly longer topic. I'm going to be speaking about contempt of court, and this is obviously a topic of great importance to journalists. There have been quite a few occasions when Indian media people have run into difficulties under this head of legal restriction. There have also been a number of cases where journalists in India have been threatened with legal action under contempt of court, sometimes without any legal basis. So I'm going to be talking about all that, and as always, we will be looking at a number of cases. Like defamation, I have divided up this topic into two parts. So what we're going to do is to look at some aspects of contempt of court today, and then move on to look at the remaining aspects tomorrow. That will neatly take us into fresh topics from next Monday, so that the two big topics are out, and then of course we begin with topics next week which are all just one session each. So that is the scheme that we will follow. Can I at this stage just ask all of you if there is anything that you want to ask me from yesterday's topic? I'll just give you a minute or two, because it's easier to deal with these things as they happen rather than wait until the end of the course. Is there anything that you want to talk to me about? Ask me? No? Okay. One other thing which Shamik is going to talk to you about at greater length is that, as you know, at the end of the course, there is an assessment to be completed, and Shamik will be telling you about that in due course. I do not want to spend any time on that at this stage. So let's get going with contempt of court. As with defamation, contempt also involves balancing two big interests. In this case, one of those interests is, like defamation, free speech. But the other interest here has to do with the administration of justice, and more broadly, the concept of a fair trial. As you know, most free societies value the right to a fair trial and place a huge premium on that concept. And to ensure that trials are free and fair, certain rules have been put in place. And those rules also mean that journalists have to be careful when writing about the judiciary. So that's, if you like, the context in which we are talking about contempt of court. But do remember that contempt of court is not confined to trials, because it is possible to look at the administration of justice separately from trials, which means, for example, how do you deal with criticism of judges? In a democracy, no one is completely beyond criticism. There are some limits that can be placed on to what extent you can criticize particular individuals or particular office holders. But to say that judges cannot be criticized at all would be extremely unfair, and therefore criticism is allowed. But what are the limits? of that permissible criticism. That's the sort of thing we're going to be looking at also when we talk about contempt of court. And of course, it is equally important that in a democracy, in a free society, the judiciary is kept accountable to the electorate. Normally the accountability is an indirect one, unlike with politicians, with ministers. But it is still important, and of course it's equally important that in a free society, in an ordered society, there should be investigation of judicial corruption and judicial misbehavior. Unfortunately, judicial misbehavior is not unheard of, and this is as true of India as it is of other countries. And I'll give you examples of where serious allegations have been made about judges misbehaving. And those allegations will have to be investigated. Usually, the media plays a role in the investigation of those allegations. So, of course, official investigations are conducted by other authorities. Now, when you're talking about criminal trials or trials in general, then you must have heard the phrase trial by media. And usually this is mentioned in a disparaging way for understandable reasons. Trial by media is not encouraged. Why? Because the assumption is that everybody deserves a fair trial by a properly constituted authority, which usually is the judiciary. So if someone commits an offense or is alleged to have committed an offense, then the forum in which he or she is tried is usually a court of law. So therefore, there should be a trial by judges, not by journalists. That is a normal assumption, and therefore you will hear a lot about the risks of trial by media. In relation to contempt law in India, the position is that it is covered both by statute, that is law made by Parliament, and by common law. I told you 2 days ago that much of the law of defamation in India is covered entirely by common law and almost entirely by English common law. But in the case of contempt, there is actually a statute, and that statute is what governs, to a large extent, contempt of court, particularly in relation to what you as journalists should know about contempt. Now, having said that, this topic is also important for another reason, and that is, there have been attempts in many countries, in Asia and beyond, on the part of judges to silence the media using the law of contempt. I briefly referred to this when I spoke about defamation. At the start of my lecture on defamation, I said that defamation must be distinguished from contempt of court. And the reason I said that was that there is a tendency, unfortunately, on the part of some judges, not all, to use the law of contempt instead of the law of defamation when they feel aggrieved. And that is a danger that all media persons should be constantly vigilant over, because for a judge to use the law of contempt against the media is relatively easy. But if they did that, then they are not following the best practice. That, for example, if a judge has been in any way injured by comment in the media, a question that deserves to be asked at the outset is this a case of defamation or is it a case of contempt? Only if the judge is satisfied that it is a case of contempt should he resort to punishment for contempt. Otherwise, like anybody else, he can go and file a case for defamation. Keep that in mind, very, very important. So that is, if you like, the background to what I'm going to be talking about. Now, the basis of contempt law in very simple terms is to preserve the integrity of the administration of justice. That is, in very simple terms, basis of contempt law. I've already told you the distinction between contempt and defamation, so I'm not going to spend any time on that. What are the key features of contempt law? The first thing, again, I'm going to be very brief here because I'll describe these things at greater length as we go along. The first thing to note is that contempt law is intended to preserve and protect the administration of justice, not the reputation or the individual ego of a judge. Very, very important to remember. Secondly, contempt law is intended to protect and preserve the administration of justice, not the reputation or the ego of individual judges. Secondly, contempt law should be used sparingly. Particularly the power to punish for contempt should be used sparingly. That is to say, only in exceptional cases where the behavior of the party who has been accused of committing contempt, only if the behavior is egregious should the law of contempt be invoked. Otherwise, the courts should be quite generous and allow people a degree of freedom, particularly when it comes to criticism of judges. Thirdly, it is necessary for any contempt case to be heard not by the judge who is affected, but by a different judge, because there is a very important principle of natural justice, which means that you cannot be a judge in your own cause, because there will be a lot of unease and many questions asked if the judge who is, for example, criticized himself hears the case that has been slapped against the person who has criticized the judge. So for those reasons, always somebody else will hear the case. And fourthly, there is an important principle that even if the court comes to the conclusion that a person has committed contempt, that person should be given an opportunity of apologizing and being let off rather than being punished or before being punished. So the court will always ask the person, look, have you understood why you're being convicted? Do you have anything to say? Do you want to apologize? And if the person genuinely apologizes, then the court should leave it at that and not punish the person. Yeah.
So as you have rightly said, that an aggrieved judge always resorts to contempt rather than defamation. Has there been any instances that the judge has gone for defamation? Because what we understand is only a contempt because he has the power, he is not satisfied, he just goes for a contempt. I mean, in India, you know that we are not supposed to sit with cross-legged. We are supposed to stand, and there are certain etiquettes also in the courtroom we have to follow. If we do not know even, we are subjected to a big contempt.
I have not personally come across any case in India where a sitting judge has sued for defamation. That does not mean it does not happen. It is simply that it has not been reported.
So it's not very common.
There is a case of times now, the judge has.
Yes, but that is a very clear example of a retired judge. I was talking about sitting judges. Justice Sawant is not a sitting judge. So to answer your question, it is extremely rare, at least in India, to hear of cases involving sitting judges suing for defamation. So I hope that answers your question. Just very briefly, this is not very important, but you mentioned sitting cross-legged in court is not by any means contempt. Okay, I'll explain to you later on.
This is told repeatedly in the courts. You can't see cross-link.
You are quite right. There are many judges who tend to be very sensitive about such things. And I'll talk about that later
Not
on.
even the judges, sir, even before they come,
Yes.
even
The
the
inspector
court
will-
officers.
The court staff. Yeah. And that is wrong. Give me
Sir.
just 1 minute. I'll come back to you.
So, as you mentioned, a contempt case must be heard by a judge other than the one offended. But is it, so do you think that it creates a, so even if a contempt case is slapped against a party by a judge, in a case which is of course not a contempt case originally, but it would create some sort of a bias in the mind of the judge because he's charging the person for contempt in the first place. So is the original case also transferred to another judge, or this judge continues to hear the original case?
Now, I cannot quite understand what you mean by the original case. What do you mean?
As in the case during which the judge has slapped, so when one of the litigating parties has been slapped for contempt, right, rather than the media per se, when one of the litigating parties has been...
No, what do you mean by one of the litigating parties?
One of the parties
Give
involved.
me an example. Give me a real life example.
Say there's a civil case,
Yeah.
not necessarily a criminal case,
Okay.
and one of the two parties,
Yeah.
either say the defendant, has been charged by the judge for contempt for whatever
For
reason.
what?
Maybe for like criticizing the judge in public, which might have been a grey area between a contempt and a defamation case.
That will very rarely happen. I can understand in the case of litigation, normally contempt happens when one of the parties disobeys an order.
Yeah, okay.
Okay, let's assume that happens. Then,
So assuming that happens, would it create some sort of a... But in that sort of a situation, you don't assume that a bias is created when
no,
disobedience is
because
done.
that will be dealt with by the same court. It is just a disobedience of the order to the
Yeah.
court. Now, it is very rare, what you said earlier, of one of the parties, while the case is going on, criticizes the judge. I would be very surprised if that happens because it would be suicidal for that party to do so. Okay, so I can't personally see that happen at all. Okay, theoretically it's possible, and if that happens, then also, if the judge decides to deal with that first before the case is complete, then the case will have to be referred to another judge, and that will be a separate proceeding. It will almost become like satellite litigation. It's not actually litigation; it will be more a prosecution. But such instances are almost unheard of. Okay, so the principle still remains that if it is a case of contempt of that sort, it will have to be heard by another judge.
So will you be referring to Justice Kannan's case in any way?
I will indeed, yes, absolutely. Very difficult
Right.
to avoid it, yeah.
Yes.
Unless you want me to avoid it.
No, no, no.
Okay, all right. Fine. Okay, anybody else wanted to ask anything at this stage? No? Okay, let's move on. So, I told you about a few basic principles concerning contempt law. Now, there are also a couple of other things to note when we're talking about basic principles. There is the principle of open justice, which is very relevant in this context. Most free societies allow their courts to be open and the justice that is administered in the court to be transparent. In other words, you do not have a situation where the courts are, or the hearings in courts are held in secret. There are there's a small number of cases where secrecy is necessary. For example, if a case is about national security, then clearly there may be reasons why the hearing cannot be a public hearing because some secrets might be let out. Similarly, if it's a case about blackmail, also sometimes a judge may decide to hold a hearing in secret. A third possibility is litigation involving patents or any other similar intellectual property disputes where the leakage of information can have serious commercial consequences for the parties. There again, it's possible for the court to be held in secret. And of course, in India, one very important category of cases which is always held in secret are terrorist cases. You know that there are cases of terrorism, as happened, for example, in the Ajmal Kasab case in Bombay. That was held in a courtroom inside the jail in Arthur Road prison. But even there, technically, it was not a secret court. It It was a court functioning inside a jail to which members of the public were not admitted as a matter of course. My understanding is that you could, if you wanted to attend that hearing, go after seeking permission. Because there were, I think, a number of non-lawyers involved in hearing, in sitting in on the case. So it is possible to regulate the entry of people. But generally speaking, the principle is open justice, which means any court in India is open to members of the public. So you could walk into any court. Now, obviously, there are limitations, physical limitations. If you had a case which is very interesting, and naturally there are a lot of people wanting to attend, then there has to be consideration given to the physical limitations of space inside the court, because there might be seating for not more than 50 people, even if it was a large enough courtroom. And you cannot allow overcrowding in a court in a way that you can allow overcrowding on a train or on a tram. So, what the court will do is to say that we will only admit 50 people. Anybody else who wants to come in will unfortunately be denied access. Now, in many countries, what they do when that happens is arrange for the proceedings to be shown on CCTV in another room. So you'd have a larger hall where people who could not get into the courtroom can sit and watch the proceedings on a CCTV screen. They don't have to do it, but they do it because they want to show their commitment to open justice. I'm personally not aware of any case in India where that has been done. I'll give you an example of a case which was which involved a massive spillover audience, and that is a case which was heard by the Supreme Court of the United Kingdom a few months ago, involving Brexit. You know, the Brexit litigation, very, very important in the life of the United Kingdom. It attracted so much interest that there was no way people who wanted to come in could be accommodated in the hall in which the court sat. So a spillover room was created and people were allowed to sit in there. In fact, that case was so popular and so interesting to everybody that they could not even accommodate all the lawyers involved in the case. There were about 180 lawyers involved. All of them could not be accommodated. So even the lawyers, some of the lawyers were asked to sit in another room. Obviously not ones who were going to speak in court, but the ones who would be assisting the main lawyers. So that is possible, but open justice is an important principle. Judicial accountability is important as well. It is true that judicial accountability is very different from political accountability of politicians, because politicians are accountable to the electorate. They submit themselves for periodic elections. If you're a minister, you're also accountable to Parliament or the state legislature, not so judges. So in that sense, judges' accountability would be slightly different, but they're still accountable, and they're mostly accountable through their judgments. So whatever they write is public property. Anybody can read, comment on, criticize judgments. So judicial accountability is quite important. And judicial accountability also, to some extent, involves the behavior of judges. So if a judge misbehaves, then how is that going to be found out? The only way it can be done is by allowing people to watch the judge perform his duties in public. That's why, again, the system encourages people to attend courts. So to that extent as well, there is a principle involved in favor of open justice. Then there is the issue of judicial authority and dignity. Now, on the other side of the coin, judges need to maintain a certain level of authority and a certain dignity. In that respect, they have to be given, if you like, certain privileges which others may not get, a bureaucrat may not get. So, for that reason, certain rules are imposed, including how others should conduct themselves in court. Not necessarily by not sitting cross-legged, but you cannot treat a courtroom in the way that you would treat a government office. So, to that extent, you can't just walk in and walk out, keep chatting. All those things are not permitted because the dignity of the courtroom has to be respected. And of course, there should be minimum interference with freedom of expression. Remember, interference is not completely ruled out, but the interference has to be minimal, and that again is conducive to the proper administration of justice. And of course, I have told you already that the power of contempt needs to be used sparingly. It should not be used willy-nilly, and a judge has to be very careful about when he steps in to assert himself through the use of the contempt power. So those are the broad principles on the basis of which the law of contempt needs to be applied. Now, what are the interests to be balanced? We have already seen them. Essentially, on the one side, you need to respect and ensure the sanctity of the judicial process, and on the other side, you have to have transparency in the administration of justice. And judges can be criticized, but the criticism must not be so intemperate that the public confidence in the administration of justice is shaken. This is a very basic principle that needs to be kept in mind at all times, not only by members of the public, but also by the judges. Criticism of judges is not bad. I have seen a lot of people not understand this basic principle. So, several times, journalists, particularly young journalists, ask, but is it not illegal, is it not wrong in law to criticize a judge? And the short answer is no. Judges can be criticized, but you have to bear in mind the very important qualification that the criticism must be in temperate language, and the criticism must obviously be rational, relevant, etc.
So generally the principle we follow, and we have been told that you can criticize a judgment, but you cannot criticize a judge in person. Your comments?
Okay, I disagree with that, because sometimes it will be difficult to criticize a judgment without criticizing the judge.
Yes.
And I would put the principle like this: you can criticize a judge, but not his motives. So even that actually can be pushed a little bit, but I'm not going to push it. I'm going to stick to the conventional formulation and say that it is legitimate to criticize a judge, but not his motives. So, for example, you can say about a judge that the judge's understanding either of the facts of a case or of the law was faulty. Then you're criticizing not the judgment only, you're also criticizing the judge. But you cannot say that the judge decided in the way that he decided because he was corrupt. That is the dividing line. So you cannot attribute motives. Now, actually, even what I said just now is a bit mild. You can go a step further and say, in very rare cases, you could possibly say that a judge did what he did because he was corrupt. And that is because, as I will tell you later on, Indian law now recognizes truth as a defense to a contempt charge. So, theoretically, it's possible for a journalist to write an article in which he says, Mr. Justice so-and-so misbehaved in this particular case because he was beholden to so-and-so. Now that is actually attributing motives to a judge, no doubt about that. But if you can prove that statement, Indian law now allows you to do so, provided also that what you say is in the public interest. So there's a qualification to that, which I'll explain later. But the short point I'm making here is, it is wrong to say that you can never criticize a judge.
So, it's not a criticism, but I would like to draw your attention that when the 3 Talaq judgment was published in the newspapers, mainly media houses, they gave the religion of the judges, of all the bench comprised of. Sir, a judge might have been born in a particular family, but we never know that the kind of religion he practices. And what is your comment on giving that religion? In India, to some extent, the name it is established that which religion he might be following or might belong to. But somehow or other, I would like to invite your comments on giving the individual comments on the judgments and within bracket the religion he belongs to.
I don't personally see that as a big issue, but you're right. I mean, if a society is mature, or when a society becomes mature, they would usually drop these things. Now, don't misunderstand me. Don't therefore think I'm accusing Indian society of being immature. I'm simply trying to tell you that is how it is most of the time. Now, if you see the background to the case, it would be very difficult to escape the conclusion that the constitution of the bench itself was deliberately made to include 5 people of 5 different religious backgrounds, which is not to say that each one of those persons was a firm adherent of their own religious description. It is perfectly possible that one of them may be an atheist, though born a Muslim or a Sikh or whatever. Now, but symbolism matters in societies like India, and therefore the symbolism was highlighted by the media, and I don't see that as at all wrong, unless the media went out of its way and said something like, so and so who belongs to such and such religion betrayed his religion and said something in the judgment which he should not have said, which would be unacceptable. I don't think any of the media persons said that. So to that extent, I think simply drawing attention to the fact that there were people from 5 different religions is not a bad thing. According to me, it's unnecessary, but it is harmless. No harm has been caused. Okay? Yes.
Can we criticize the judge during trial process?
Give me an example. No, hang on. Just wait. Let him complete.
Okay, let me, in the case of Triple Talaq case, when judgment for trial were on, or in the case of Justice Karnan case, when Karnan, he himself said for the court in his,
official residence.
Official residence. In that process, does he have the liberty to criticize?
Okay, there are 2 different things, because what was happening in the Triple Talaq example is a legal proceeding, not in the Kanun case thing. Kanun was extrajudicial, it was outside the court. Okay, so there are 2 separate things. Now, generally speaking, it is inadvisable to criticize either a judge or aspects of a proceeding while the case is on, generally speaking. And the reason is that you will have to wait and see what the verdict is or how it is dealt with in the end. In other words, don't jump the gun. That's the principle important. But that is not an inflexible rule, because if, for example, in the course of an extremely important case, a judge decides to exclude what almost everybody would consider to be a vital witness. He says, I'm sorry, I'm not going to hear such and such person. That can be a matter of legitimate comment, because by not commenting at that stage, you are effectively signaling the acquiescence of society to what has been done. Whereas if, for example, it was drawn to the attention of the judge through sober criticism in the media that what he did was not right, he may rethink and he may correct his attitude. So, in a constructive way, it is possible for criticism to be made, but not in a manner that is likely to shake the people's confidence in the judiciary. Sorry, you wanted to say something? And then
Yes, you asked for an example. There was a fire in a hospital in Calcutta, EMR.
Yeah.
So 92 people died. The trial was going on. The family members of the victims repeatedly complained that one of the accused was not attending court in all the trial dates, but he was appearing in all other public programs. The accused were all industrialists. So what happened? I was covering the trial at some stage. So the accused used to come and sit in his car outside the courtroom. And the judge would never ask him to appear in the courtroom. So the family members always had this complaint, and also the judge would address all the accused as shy. So the family members always was very agitated. Why is the judge showing a little bit of partisan attitude towards them? So I wrote that the person was not in court. He was waiting in his car while the trial went on. But how far can a journalist go in writing this? I mean, can he be critical of the judge in this case, saying he is not asking the accused? I mean, there is a process where the lawyer of the defendants, the judge asks whether all the accused are in court, so everyone is asked to stand up and show that I am here. So this person was always excluded. So how far can a journalist, this criticism has to be very sober, or it can be very scathing also?
Well, the first point to make is that a journalist would be fully entitled to draw this matter to the attention of his reading public. There's nothing absolutely wrong with this. Secondly, the journalist, if he was genuinely diligent, will find out whether the court has given any reasons for exempting this person from remaining present in court during the hearings. Sometimes there may be a judicial order. If that is the case, the journalist will look silly if he make a complaint of it, because the judge himself has authorized it. Then they are quite justified, the concerned parties are quite justified in not turning up in court. Thirdly, if there is no such order, a journalist should be completely justified in questioning the special treatment given to these people.
If there is a judicial order,
Yeah.
can that order be criticized?
It can be criticized, but you will have to be careful in criticizing it, because ideally you should talk to the lawyers on both sides, but particularly the lawyers for the victims, and ask whether they did anything to challenge the order. Because remember, when an order is passed by the judge saying X, Y, and Z don't have to turn up in court every day, then it is open to the lawyers for the victims to appeal against that order, or to make a representation against that order and ask for that order to be modified. But if they did not do it, and if they did not consider it unusual or unacceptable for these people to be exempted, then it would be a little odd if a journalist made a big issue of it, unless the journalist has reason to suspect that some sort of a favor is being shown to those people. It is very fact sensitive, so it's very difficult for me to give a general principle. But in some circumstances, a journalist should be justified in raising this as an important issue, but always in sober language. Because before you begin to hit out at the judge and hint that he did it with ulterior motives, it's a good idea to check your facts. So I would say that comment is probably justified, but it will have to be after a number of inquiries have been made.
On what grounds this kind of exemption is given?
Usually it would be something like medical grounds. If a particular witness is ill. Ill does not mean confined to hospital, but ill for other reasons. It has to be fairly serious, not that he's got a common cold or something like that. But also sometimes because genuinely, without any favor being shown, a particular defendant may be busy. Not busy in the sense of making money, but busy. For example, if the person is discharging a public duty, then in those circumstances, I can see a reason why a judge might say, I exempt you, but it will be very rare for the exemption to be wholesale. In other words, you don't have to show up at all, except on the date of sentencing. That would be rare. If anything like that happened, then I think serious comment is called for from the media. So everything depends on the facts of the case. But it is not unusual for defendants to be exempt from turning up at every hearing. Normally they'll be expected to be there. Okay, anyway, yes.
So is it possible that a judge's conduct or something that he says outside of the courtroom, in the sense outside of the judgment, the written judgment that he's giving, if that is intemperately criticized in like really harsh language, can that be a grounds for contempt of court? My context to this is a situation which happened in the Jaipur High Court,
Yeah.
where this judge made certain ludicrous comments about like the sexual relationships between people and the pious nature of certain things, etc., which were not just unscientific but like frankly really stupid. So this was remotely connected to a case, but in no way was it a part of a judgment of some sort, and it was like a public statement that he made.
Yeah.
So in that sort of a situation, will really intemperate criticism of this in the press or by anyone be open to contempt?
Contempt is unlikely, defamation possible. It depends on how the article is worded. Okay? Contempt unlikely, because the answer to that will be it is no part of the judge's job to make the speech of the kind that he made. I'll give you one or two cases on that shortly. So no, you could criticize the judge's behavior under those circumstances. Okay? Anything else?
So one question. Does a journalist have right to see any document filed by any of the parties to the court? I mean, if yes, then who to approach?
It's an extremely complex question which I will deal with when I take up the topic of right to information. Okay? Anything else? No? Okay. Let's move on. Sorry.
One more thing, we talk about administrative relativism, right? But in case of judiciary also we see like, holidays after holidays just for trivial reasons. But in media generally, we generally, kind of do not have the, what should I say? We generally do not write about these kind of things. Because we all know the number of cases pending in most of the courts, but we don't have that thing in us to write about the system. So is it, kind of allowed, or will it again, kind of invite contempt?
Yeah. No, it will not invite contempt. It will be entirely legitimate to comment on such matters. In fact, completely by coincidence, this morning in the Indian Express, if anybody has got a copy, you can see on the front page, there is an article dealing roughly with what you're saying, and it has to do with the Calcutta High Court, where the number of judges currently sitting is less than half the sanctioned strength, and a judge of the court has very strongly criticized this state of affairs and given reasons why he thinks that this is going to cause a lot of injustice. So if a situation like that arises, it will not only be proper for a journalist to write about it, but I would say it would be a moral duty on the part of the journalist to write about it. So yes, there's no difficulty at all.
This Indian Express thing, if I'm not wrong, it is about the appointment of 7 judges, which has been held for quite some time. But this is about the appointment of judges, right? But in case of the whole judiciary system, the system goes slow. So do we have the right to write against the system itself? Because this is about one-off thing, appointment of judges.
Actually, the article is slightly broader than that because it's quite a long article. If you look over the page to page 2, you'll see a lot of other things being said. But to answer your question, the answer is absolutely yes. You could even write about the detail of your criticism. For example, so and so in the High Court is a non-performing registrar or whatever. Absolutely no problem. As long as you're careful about your facts, so that you don't invite a charge of defamation in the process. If you get your facts right, you can go hammer and tongs about such issues because they are of vital public interest. Administration of justice is a matter of great public interest. So if you are talking about the ills within the judiciary, absolutely, no question about that. Okay, let's move on. So as I said, judges can be criticized. And I'll talk, when I give you cases, you'll realize how this principle has actually been put into practice, either rightly or wrongly. There are 2 types of contempt. One is civil and the other is criminal. little bit like the division we saw in defamation, civil defamation, criminal defamation, but here it's slightly different in terms of how you define each one of them. Civil contempt essentially involves willful disobedience of court orders. Please remember the word willful, very important. In other words, deliberate, not accidental. Sometimes, genuinely a person may do something which amounts to disobedience of a court order without meaning to do so. But of course, you'll be put to a standard of normal responsibility. So how would a responsible person act? That's a test that will be applied. And if it turns out that a responsible person would have done something, and yet this person made a mistake. So, to give a simple example, if there is a proceeding in a court in respect of which there is a limited suppression order, that is to say, certain parts of those proceedings should not be reported, and you as a journalist do not know about that suppression order. You made inquiries but could not find anything to that effect. So nothing, for example, put up on the notice board, etc. And therefore you went ahead and published something. Now technically you have disobeyed the court order, but you have a defense of not having done so willfully, and therefore that would not be deemed to be contempt. So one has to be careful, because here the question that we asked is the extent of your due diligence, and there can be some disputes about that, but broadly speaking the principle is that if you don't willfully disobey an order, you are not in contempt. On the other side, you have conduct which is calculated to scandalize or lower the dignity of the courts or judges. That is essentially what criminal contempt is all about, and there is a lot of debate on that issue nowadays around the world, including to some extent in India, about whether scandalizing the court or scandalizing judges should remain a criminal offense at all. In some countries, that offense has been removed from the statute book, including the UK. So in the UK, there is now no offense of scandalizing a judge. So that's a debate which will go on for a while. I do not think there is a prospect of that offense being removed in India soon, but it may happen.
So,
Yeah.
so in the example that you just gave about civil contempt, wherein limited reporting, like the limit has been imposed, etc. In that sort of a situation, does a journalist have an active duty to find out what the situation is regarding that order?
Yes.
Or if he's just like, if he doesn't get to know, he does have an active duty?
No. You have to have at least a minimum duty to find out. So, for example, you will first of all look at all the notice boards. Normally, these kind of things will be displayed in notice boards. Secondly, you will ask the court clerk, are there any suppression orders? You will ask your colleagues. You may even ask the lawyers involved. Now, to what extent you do it will depend on the facts of each case. How sensitive is the case? How likely is it in that case that such an order may have been passed? If it is a routine case, then you can be a little more relaxed than if it is a sensitive case. So you have to make a judgment. Secondly, you will also, when you become a court reporter, you are expected to have a degree of general legal knowledge. That is why you have training courses for journalists, which I know doesn't happen in India, but I'm just telling you that court reporters are seen to be slightly different from normal reporters, in that they at least should know something about the legal system and how judicial proceedings work. So the extent of the duty might be debatable, but there is no doubt that there is such a duty. Okay? Yeah.
Does it have any special qualification prescribed for reporters or reporting for?
No, absolutely not. In fact, most countries do not have any qualifications for being a journalist. It is a reality. In spite of the fact that journalism colleges thrive in India and in other countries.
But I think it's in Supreme Court.
No.
Journalists have to be law graduates of a Supreme Court.
I saw something to that effect a few years ago, and I was astounded because, quite frankly,
Many judges oppose that.
sorry, yeah, no.
Most of the journalists covering Supreme Court and law.
So I think what he's referring to.
That is because of their own interest, not because it is compulsory.
Well, actually, the accreditation card is not.
Correct. Accreditation is different. Your question was, do you need to be one? The answer is no. Accreditation is different. I am talking about a situation where you want to cover the courts, even if you are not a degree holder. Forget law degree holder, not a degree holder. You haven't been to university, but you're a good writer. Perfectly possible. Journalism is a profession where, unlike medicine or law or architecture, you don't need to have a degree to be able to do your job. I'm not therefore advocating that people should not go to journalism colleges. I'm simply telling you that the reality is journalism is one of the few vocations for which no qualifications need to be prescribed. There are many people who write extremely well who may not even have gone to a college, to any college. So that is the context in which I gave you my answer. And definitely for court reporting, no. It will be very rare, except as you say for accreditation purposes. Okay. Anything else?
So, one thing. Generally, judges don't talk to reporters, but there are some judges who meet, and then if we have any question, they explain the nature of the order. But is a register, open to press? Register general.
Register what?
Of the court. There are many registers at the website or.
I can understand your anxiety to get that information. I'm very happy to talk about it, but please bear with me till I talk about right information. Okay? Because it is a very complex topic. If I begin to talk about that, we'll be losing a lot of time and we will not be able to deal with our topic. Okay? So I'll talk about it later. And do remind me if I don't address your specific question. Okay. Anything else while we move on? Yeah.
So, just to talk about the qualifications for journalists, right, especially for courtroom reporting. So, if a journalist isn't qualified, he runs an extremely high risk of misreporting, and consequently, readers will tend to blindly believe what that person says, right? So, don't you think that in the interest of the readers, at least you need to have, say, if not a complete 3-year law degree or a 5-year law degree, as it may be, at least a course on which you know what the basic legal terms are. Because when you listen to live court sessions, they obviously use legal terms which aren't in common parlance, right? So in that situation, don't you think it sort of becomes mandatory for journalists to have some sort of basic knowledge of how of the terms that are in frequent use in a particular profession?
I couldn't agree with you more. Absolutely correct. And that is what people like me do when we go around the world conducting workshops for journalists on media law. But the point I was making was a general one, and that is, it is still possible for a person who has not acquired a legal degree or a degree in journalism to do a good job of court reporting. Now, how does it happen? It happens largely because of apprenticeships. In my part of the world, in the UK, there are many court reporters who have, as I said, never been to college, but who are first class, who are sometimes actually sharper than lawyers when it comes to certain things. And how did they acquire that proficiency? Through sheer experience, hard work, diligence, practice, whatever you call it. Remarkable. It's a pleasure dealing with such people. There are times when they actually point out to lawyers that they could have used a different formulation to stay on the right side of the law. Possible. But I agree. And increasingly, there is a need for at least a basic course of familiarity with terminology. Normally what I do, and I did not do it on this occasion for two reasons. One is because I'm very conscious of the fact that I'm addressing a mixed audience. And already I have, from the point of view of the law students, dumbed down what I'm talking about. And I didn't want to dumb down further. Secondly, also, lack of time. Otherwise, what I do is, as part of my first lecture, there are 3 slides which give basic legal terms, about which there is so much confusion in India. I'm very conscious of every day I open a newspaper, I can find at least 2 or 3 examples of mistakes on basic terminology. It happens all the time. But for those reasons, I could not address those. I do that when I speak in a dedicated way to journalists. And so, yes, what you say is entirely correct, and it has to be the case that people will have to at least have some familiarity before they go to court. Because they not only expose themselves to ridicule by making mistakes, but you're quite right, they also seriously mislead their readers, their listeners, their viewers. And this is particularly true nowadays with television. That day, 3 or 4 days ago, when you had a problem in Haryana, I was watching TV, and I was both amused and angry at the number of mistakes the reporters were making in covering something as basic as the legal proceedings there. Just in reporting, not in terms of analyzing, just reporting. There were so many mistakes being made. So there is a problem, undoubtedly. Okay, any other questions? No? Sorry, yeah.
Can any form of liability be ascribed to someone who wrongly reports, say, a court decision because they don't understand? Like, for example, in the Triple Talaq case, many reports initially carried that because Justice A had read his opinion first, because he was Chief Justice, and although his opinion was a dissent, they carried that as the opinion of the court for some time. So can any sort of liability be ascribed to such reporting?
There is liability at one level if the report happened to be completely wrong, false, misleading, whatever, and that is, in an extreme case, contempt of court, distorted reporting. But usually that doesn't happen. It is more shoddy reporting rather than distorted reporting. In other words, whoever reported that did not do it deliberately. It's just that they didn't know how to go about it. So in that sense, there's no liability. But there can be liability in, I can think of situations where usually people don't pursue this in the courts. But for example, if it's a commercial case, and then there's a very misleading report about the commercial case which has consequences for the parties. I can give you a hypothetical example. Suppose there's a fight between 2 companies and there's a judgment of a court, and the court judgment is improperly reported. So as the improper report comes out, the share price of one of the companies falls drastically in the share market. That can be a very serious matter to the company. And the company can, in a given case, sue the reporter or the newspaper or the TV channel for malicious falsehood. That is possible. It rarely happens, and quite frankly, in India, there's not even an incentive for anybody to try to do that, because assume if a case takes 30 years to be heard, what is the point? By which time the parties may be dead. So nobody usually takes this thing seriously. At the most, they might ask the newspaper or the TV channel to put out a correction. But sometimes the correction is too late. The damage may have been done. So there is a problem there, but it is not something that leads to liability of the sort which is punished most of the time. Okay, let's move on. In terms of the legal provisions, first of all, there are 2 provisions of the Constitution of India which need to be noted. 129 and 215, which allow the Supreme Court and the High Courts, respectively, to punish ex facie contempt summarily. Ex facie means in the face of the court. That is to say, if, for example, to take a simple and extreme example, if you are sitting in the High Court in Calcutta one day, when court proceedings are going on, and in the middle of those proceedings, you suddenly feel the urge to shout. Okay? Inexplicable, but can happen. That conduct will be called contempt in the face of the court. So the court can just immediately punish you without asking you, allowing you to go through a trial. Normally when there's contempt committed, the accused person will be given a trial. But when it is ex facie contempt, then punishment is immediate, summary punishment, possible. Even then, quite frankly, a judge has to be very careful. Simply because somebody shouted does not mean they will immediately be sent to jail. there has to be a certain natural justice process to be followed. But that's what these provisions allow the court to do in terms of summary punishment. But more importantly, you have to concentrate on this law, the Contempt of Courts Act of 1971, which defines criminal contempt as follows. Any act which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. So just see how broad the formulation is. Scandalizing or tending to scandalize. Now what is scandalizing? There can be a debate. But essentially, it is something which will bring the court to such disrepute that people will lose faith in the judiciary, or which lowers or tends to lower the authority of any court. The authority bit is just as important as the dignity bit, or which prejudices or interferes with or tends to interfere with the course of any judicial proceeding. So if you try to interfere with judicial proceedings, then that will become an act of contempt. Or which interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any manner. So interferes with or obstructs the administration of justice in any other manner. A very simple example of the last category would be if you allow your mobile phone to ring while court proceedings are on, because it has the effect of interfering with the administration of justice. So there are so many things that can be brought under this head, but those are the sort of things that would be seen as unacceptable conduct. I'll come to you in a minute. Yes?
Sir, if a lawyer is not wearing the proper attire of the court, which generally happens in the trial court, so can the court punish him under the Contempt of Court Act?
In theory, yes, but it would be extremely rare unless the person comes in such outrageous apparel, right? It is not uncommon today in many parts of the world to see people come to court in jeans and t-shirt. Okay? When I say people, obviously I don't mean lawyers, I mean members of the public, right? My personal view, and I may be completely wrong, is that that is disrespectful to the court. You have to come formally dressed when you go to court. Doesn't mean you will always be in a suit, but at least a degree of formality. But that is acceptable. Okay, I have seen, I've personally seen people turn up in jeans and t-shirts who are not punished, and that's considered alright. But you cannot come in a vest or just in a way. You know, that sort of the thing would be totally unacceptable, and that can be contempt. Yeah. Yeah. Sorry. Yeah.
As opposed to the wider ambit of criminal contempt, which is highlighted here. In the previous slide, we had gone over for civil contempt was willful disobedience of court orders. Could you also elaborate on, like, is that the entire scope of civil contempt of court?
It is, but it is very big. So I don't want to deal with every aspect of it because most of the aspects of civil contempt are not applicable to journalists. And my focus in these lectures is media law that applies to journalists. Contempt of court applies incidentally not only to the media, but to a lot of other people. It applies to the parties, it applies to the public, it applies to lawyers, it even applies to judges. So in those circumstances, I am not dealing with those other things. That's why I'm focusing on what is relevant to the media. Okay? Somebody else wanted to ask me something. Somebody else put up a hand there? Okay.
So I understand that under the articles of the Constitution, like, the burden of the judges should usually be higher and they usually be more circumspect about applying those articles in cases of contempt. But would it theoretically be legal for them to punish journalists for contempt under those articles summarily without, like, giving them the authority?
Theoretically, yes. Practically, no. Again, it depends on the conduct. Suppose, completely by accident, a journalist forgets to switch off his or her mobile phone.
I don't mean conduct during the trial, in the sense in case of certain kind of publication.
Yes.
Which supposedly scandalizes the judge.
Okay.
So in that sort of a situation, would it, like, can they use those articles or do they have to?
No. This is only in the face of the court. Only what happens in the courtroom. In the face of the court. That's why it's called ex face. Okay? Right. Anybody else here?
If a reporter gets relevant information about the accused or the victim, whoever, substantiated with evidence while the court proceeding is on, can he or she write about it?
What
Will
kind
that
of
be
information?
interfering with the case? Suppose
Yeah.
the accused has past record of criminal offense.
I'm going to
Can
come
that
to that. Okay. The short answer is no. The short answer is no, but I will explain it in greater detail. That's a very important part of the law of contempt. I'll talk about it a little later. Okay. Anything else here?
Will you be dealing with sub judice to some extent?
Of course. Yeah, absolutely. Yeah. Okay. Is that it? All right. Let's move on. So these are the sort of things that are covered by the Contempt of Courts Act, the main section in the Contempt of Courts Act. Now, what are the acts likely to constitute contempt? To some extent, many of the questions you have just asked me are covered by this slide. So, again, this is not an exhaustive list, but this is a reasonably comprehensive list for journalists, for media people. First of all, filming or recording on court premises, completely disallowed. You cannot do this at all. Okay. Secondly, making payments to witnesses. So, if you're a tabloid newspaper and there's a sensational criminal case, a murder case, which is going to be heard after 2 or 3 months, and just to boost the circulation of your tabloid newspaper, you get hold of one of the witnesses who's going to depose and say, you know what, if you spice up your evidence a little bit, we'll pay you so much. That is, again, completely unacceptable and be a clear case of contempt. Publishing information obtained from confidential court documents, to some extent it refers to your question, which I'll talk about a little later. So if you were to publish information that is in confidential court documents, certain court documents are open to everybody, but certain documents are confidential. Reporting on a defendant's previous convictions, that goes to what was just asked. Generally speaking, you should not report on a person's previous conviction. Yeah.
Suppose that the accused of a particular case has a criminal history.
Yeah.
So while reporting on that, one paragraph of his criminal history, of his convictions and acquittal, it's not allowed.
Well, it's very difficult in the Indian context to talk about not allowed, but it is not advisable when we put it like that. And I'll tell you why when I deal with that particular.
That can also prejudice a fair trial.
Yes, absolutely. And I'll tell you how a little later. Okay. Launching an organized campaign to influence court proceedings. So if you set up an NGO saying X has to be convicted and sent to jail for life before the trial takes place, that would be contempt of court. Though sometimes passions run high, for example, in the nearby case, people did feel strongly, but that doesn't mean you set up a campaign, because the theoretical assumption is that that can influence the trial, and even a terrible criminal does have a right to a fair trial. That is the basis on which these rules are made. Reporting on court proceedings in breach of a court order or reporting restriction. I've already told you sometimes there might be a court order which says do not report on this aspect of this case. Sometimes there may even be a court order which says do not report on this case till another trial takes place, because what happens if this trial may influence the other trial? They are rare, but they can happen. Also, breaching an injunction obtained against another party. Suppose there is an injunction given by a newspaper, by a court, which says to one newspaper, don't publish anything about this particular aspect of a case. Other newspapers know about it and they still go ahead and publish. That would also be contempt, because you are supposed to obey what has been publicized as an order, even if it is against only one newspaper.
So the injunction is in terms of only one newspaper.
I know. Normally, injunctions have to be specific against individuals. But in rare cases, and I'll give you one example which happened in England in a very big way, where the matter was so widely publicized that it would be impossible for anybody to not to know about the injunction given against State of England newspaper, and then you take advantage of the fact that your paper is not named in the injunction order, you go ahead and publish. Go ahead and publish. The court will not allow that. So it's a common sense matter. Okay, anticipating the course of a trial or predicting the outcome, generally speaking, should be avoided. In other words, for a newspaper to say, we are absolutely sure that X is going to be convicted and sent to jail for 20 years, when the trial has not even begun or has not finished. That again is not acceptable. Revealing the identity of child defendants, witnesses, victims of sexual offences, about which I'm sure you know. So if you know the identity of a rape victim, you should not reveal their identity except in very rare circumstances which I'll explain to you later on.
So what's the problem in speculating about the possible verdict of a trial?
Okay, speculating is a slightly ambiguous word. If you say his crime is so heinous that it is very difficult to imagine him being let out scot-free, that's okay. But if you say his crime is such that nothing other than a conviction followed by a life sentence will do justice, that is not acceptable. Because you are putting pressure on the judge.
So, but I mean, the fact is that such criticism or such opinions in general exist in society, right? Even not from the journalist's point of view, there will be news, debates wherein lawyers will voice their opinions. The most distinct case that I remember was the Salman Khan case, wherein right after Harish Salve had gotten him the relief, there was this flurry of people and lawyers who were on news channels who were debating how it's just his influence which has gotten him away, etc., etc. And that was too direct. They were not even holding back on thoughts, right? But my question is that judges generally, inherently by the position that they occupy, are supposed to be separate themselves from this media influence. Something that something that we don't celebrate, but something that happened, say, in the Kaushal case also, right? Wherein there was immense media pressure, yet the Supreme Court didn't, unfortunately so, but didn't bow down to the media pressure. So, I don't see a huge problem in, because at the end of the day, it's free speech which the media persons are exercising. Right?
I can see the thinking behind what you say, but it is still wrong for a journalist to say, as I said before, that the only outcome possible in this case is for X to be convicted or for X to be acquitted. That is unacceptable, full stop. However strongly you feel, you should not put it in those terms. Privately, yes, you can speculate. Actually, I'll tell you why this particular principle is not that relevant in India now, is because you don't have the jury system. These principles were actually directed against the jury. Because remember, jury members are ordinary people. They can be influenced in a way that the judge cannot be. So if you said something as strongly as that, there is a fair chance that members of the jury may be influenced. So I agree that the force of these provisions may not be quite as strong as they are in a country where there is a jury. But it is still considered necessary, because remember, at the end of the day, judges are also humans. So if you put too much pressure on a judge by media comment which says this person has to be convicted, that is seen as not good for society, whether you like it or not. What the contempt of court law says is, hold your tongue. It doesn't say don't comment, but hold your tongue till the court case is over, and then you say what you like. But don't do it before the case is concluded. It may not convince you, but that's the state of the law. But there is a lot of freedom to talk about the case. It doesn't mean you have to keep silent about the case. It is simply that you don't say that the judge has no option except to convict him or to acquit him. Okay? Yeah.
So on this idea of launching an organized campaign,
Yeah.
where do you draw a line? Because as you said in the Nirbhaya case, a lot of people came out in sympathy of the victim and they expected a particular outcome from that sort of a case. And there were campaigns, maybe not directly to influence the verdict, but just to display their anger with the whole situation. So in that sort of a situation, where does the judge suppose that, okay, this is now directly influencing the verdict and this is just a protest of some sort?
Okay. At one extreme, if there are candlelit vigils in front of the courthouse, that would be very close to being unacceptable. Because you can't sort of put pressure on the judge by saying, you know what, we've got a mob here which is willing to stand by. That's not acceptable. On the other hand, if it was a very sober campaign in a newspaper which says this crime is just too heinous for society to tolerate and for the criminal justice system to condone, that sort of a campaigning is all right. There is no fixed dividing line that can be drawn because everything depends on the context. Context both of the case and of how the campaign is done. So it's impossible to give a single answer to your question. It depends. Generally speaking, you can express your outrage at what happened without trying to imply that if the court verdict does not go in a certain direction, the court is not doing its job. If you know what I mean. Sorry.
So would I be right in saying that possibly the standard is at a point where you start intimidating the judge or the judiciary or trying to influence them in like a little scary sort of a manner?
Up to a point, yes, largely that, yeah. Put pressure, intimidate not in the sense of saying, you know, come on, I'll kill you.
Yeah, no, of course not.
Yeah.
But in the terms of what their social standing, etc.
Absolutely. Basically that, you know, we'll think the worst of you if you don't decide the way we want you to.
Also taking from that, since an example you give is like, for example, candidate which is outside a courtroom. So in some cases, because it affects the public to that extent, it's not like the public would want to like revolt against the court, but more like they feel like they must protest and stand for the cause, and by virtue of that maybe cross this like particular standard. So in those cases, would it still be like contempt of court? Like for example, the Nirbhaya case where there were continuous candidate vigils saying we want justice, we want the person convicted, like death sentence, everything, right? But would that be looked at as contempt of court, considering it was something that affected the public like greatly?
It would, if you're talking about marching to the court in a candidate vigil, it would. But I'll give you another example where it would not, which is happening right now. I don't know if any of you have been following. Last night there was on TV a lot of discussion of the Asaram Babu case. Right? This is a fellow who is next in line in terms of sexual assaults by a so-called godman. Now, one of the points that was being made was that the case has been dragging on and on and on, and that is a black mark on the Indian judiciary. It's a very serious criticism of the judiciary, if you come to think of it. Now that, I would say, is entirely acceptable. There will be no contempt of court there, because that is an expression of the frustration at justice not being delivered. But if the campaign instead was for the conviction of Asaram Babu and say that no judge in his mind, in his right mind, would acquit the fellow, that would be falling foul of the contempt law. But you can campaign. So even what you said, there can be a campaign saying, and even a forceful campaign, saying that justice needs to be done fast. What has been happening is unacceptable. Okay? Sorry, I'll come to you and then you. Yeah.
Can a newspaper publish letters from the readers, which are kind of the readers who are venting out their outrage on a particular event, which is undergoing the court proceedings? So can that be done?
It can be done depending on the actual wording of the letters. Again, if the letter writer is quite intimidating to the judge, saying, look, you better decide it this way, otherwise there will be consequences. That would be totally unacceptable. But if on the other hand, it's an expression of frustration that justice gets so badly delayed that at the end of the day, people will begin to lose faith in the court system, then that's acceptable. Everything depends on how it is worded.
So it's on report of confidential court documents. I want to mention one case that CBI is investigation arbusting operation, and it's a court monitored investigation. So periodically this CBI is submitting the progress report and it becomes called court property. So what happens, we are also getting something out of investigating agency. So, is it amounting to contempt of court? I mean, as we are reporting progress report and we are getting from the investigating agency.
Okay, if the progress report is publicly available, for example,
it's on
secret document.
Still covered
Court property.
okay, is it a report that is submitted to the court in a sealed cover?
Yeah.
Yeah, and you get it from what source?
From CBI sources.
We are not supposed to disclose our source actually. The media.
Actually, whatever we are discussing, we are getting from CBI.
Okay, so you disclose or not? I'm trying to understand what you're
We
trying
are
to
getting
say.
from CBI.
Yeah, okay. You're getting it from the CBI unauthorized entry. Okay. Now that is quite a tricky situation because a short answer would be that you would be in contempt of court. But a longer answer is no, you may not be in contempt of court because then you have to take into account many things. Principally this, is what you're going to report or publish likely to obstruct or interfere with the administration of justice? Sometimes it may not, in which case no contempt. Secondly also, the manner in which you report it, because sometimes if you're smart, you can give out the same information without revealing the actual report, right? So there is that aspect of it. Thirdly, very importantly, even if what you did is technically wrong, do you have a strong countervailing public interest which justifies the publication of that report? Because, for example, the CBI may not be doing its job, and by publishing what you're publishing, you are exposing the CBI's either negligence or willful misconduct, which is a matter of public interest. Now, the difficulty with all this is, ultimately, these arguments will go to a court, will go to a judge, and much depends on what view the judge takes. The judge may, either because he is ignorant or because he is perverse, take a certain view which may result in your punishment. It's very difficult to predict accurately what will happen. But I'm just trying to tell you what can happen.
Sir, you mean to say in contempt also public interest plays a major role?
Up to a point.
Up to a point, number one. Number two is the contempt either could be done suo moto or somebody else has to file a contempt.
Correct. Yeah. Most of the time it's done by the Attorney General or the Advocate General, depending on whether it's central or state. But it could be anybody else. Yeah.
So you see taking from ma'am's question, like supposedly a letter is written to the editor and the letter is published. It has some intimidating words to the judge.
Yeah.
How is that interfering with the administration of justice? Or in a different scenario, if I am holding a candle march right outside the courtroom, like outside the court when the case is happening, how is that interfering with the administration of justice?
Because it has the tendency to pressurize the judge. The judge is under pressure in the case of a candlelit vigil from a mob that is coming on. I agree that they are candles, not guns, but it is a mob is a mob, right? A judge is a human being. He has to go about his normal business outside court, and the last thing he wants is to be abused. For example, if it's in a marketplace, there's no point in saying, "Oh, you can then call the police and ask the police to punish the people who are harassing him." What you want is to put out an image to the world that the judiciary is completely independent and also not subject to these pressures. And that you can only do if there is a degree of order. Because the alternative is for the same mob, and I'm using the word mob not in a disparaging way, to make its feelings known after the verdict is out. Why are you so desperate to put pressure on the judge before he gives his verdict? If he gives his verdict and you don't like it, you criticize the judge. That is allowed. Also, there is an opportunity to go and appeal. So his word is not the last word on the subject. So, in a sense, keep your counsel is the answer to what you are saying. Okay? Right, so let's move on. So these are the things which essentially would matters for you all to, if you're journalists, for you all to keep an eye out for. You cannot do any of these things.
So,
Sorry, 1 minute.
So, considering this example wherein a particular person writes an article and the newspaper publishes it, so in that circumstance, on whom, like I'm sure on the person the culpability definitely lies, but vicariously does the newspaper, is the newspaper also liable?
Absolutely.
For not...
Absolutely, yes. Because you as the editor did not exercise due caution in the publication of the letter. Yep.
So to what extent does intention matter
in content? Okay, generally speaking, like in defamation, intention is irrelevant, generally speaking. But I would add a word of caution there, because when the trial takes place, then intention is going to become relevant, at least to the extent that the court will have a good idea of whether something that was done was willfully done or not, especially in civil contempt, but also in criminal contempt. So you could, which is why I mentioned the concept of public interest. Sometimes you might say, I knew what the consequences were, but I did it because I thought the public interest needed to be served. So there are, to that extent, your intention may come out.
So is public interest a blanket defense which I will take?
No, no. But it is part of the repertoire of defenses.
So is it only a mitigating circumstance, or?
No, it can even be a substantial defense, but it is not a defense that is embedded in law, that is explicit in law. So you don't have a clause in the Contents of Courts Act that says public interest may justify contempts of court. So it is very vague, but it is well understood by the judiciary. Judges know when to use the public interest and when not to use the public interest.
So you speak about liability of the newspaper. So while in the case of the newspaper has a general control over what the editor is publishing, etc. But now, what if the intermediary is, let's say, a social network? Then will the liability arise for the social network as well, for the intermediary as well?
Okay, again, I have to defer an answer to that question. I will be talking about this when I talk in the last lecture. I intend to talk about cyber issues. You're talking about the online edition of a newspaper. Yeah, I'll talk about it, no problems. Okay, right, let's move on. So these are the sort of things that are likely to cause problems for the media. Now, in terms of how the contempt law is applied in practice, just a few points. Now, what conduct would offend the dignity of a court or interfere with the administration does is ultimately for the court to decide. Many people have criticized this principle. What they're saying is, look, you're dealing with some harm caused to judges. Why should judges be the arbiter of that harm, of whether that harm has been caused? In other words, to a lay person, this can seem like judges being the arbiters of their own interests, and that is a point which has come out in some articles. The short answer to that is, A, you have to have somebody who will decide these matters. In other words, there has to be some place where the buck stops. And normally in our system, the place where the buck stops for almost anything is the court, is the judges. Secondly, there is a safeguard against misuse of this provision, which I already told you about. And the safeguard is that the same judge will not hear the case. It will go to another judge. Now, I've heard many people say, but you know what? Ultimately, the other person is also a judge. He's not going to rule against his brother judge. Yes, I agree, it's possible, but don't always assume that is the case. It is perfectly possible for a judge to be completely independent and be objective and to say, sorry, but what my brother did was wrong. It has happened in some cases. And of course, yet another safeguard is the system of appeals. So if something happened in the High Court, you can go to the Supreme Court. So there is that possibility. And of course, in India, even in the Supreme Court, sometimes you get more than one chance to have your case being heard. So there are all those factors to be taken into account. But in terms of principle, ultimately the person who decides whether something is contempt or not, that decision is taken only by a judge. And generally speaking, of course, power to punish for contempt will be used sparingly. It's a point I've made before, so I'm not going to spend too much time on this. And only in cases where the conduct concerned is serious enough. What is serious enough, again, will have to be decided by the court, by the judge. And there can be a difference of opinion. There can be an honest difference of opinion about what is serious and what is not serious. Sometimes there can be borderline cases which create all kinds of problems for everybody, in which case, as I said, the only way of resolving a dispute would be to take the matter to a higher court. It will not be used, for example, to wreak private vengeance or to satisfy the personal ego of a judge. Very, very important point. And I'm sorry to say that this principle has not always been followed in India. There have been occasions when a judge feels that he wants to uphold what he considers to be his dignity, and therefore uses the power of contempt to do so. I'll give you an older case first, and then I'll give you a fairly recent case in India. This case involved a Chief Justice from the Bahamas Islands. Bahamas Islands, as you know, is a colony of Britain. Now, this Chief Justice had written a letter in a local newspaper about something unconnected with his work as a judge. I think it had to do with the poor sanitary conditions in the sanitary conditions on the island. And he had made some scathing remarks about how the local administration has not been dealing with those matters. When he wrote that letter, a reader of that newspaper decided to reply through a letter to the editor. So this reader responded to the criticism of the judge, of the Chief Justice, and he made certain observations in scathing language. So he rebutted what the Chief Justice had written. But then he went a little further and said, among other things, that this Chief Justice is a pompous fellow. Probably said something like he's a shirker of his work. He may even have added something to the effect of it would be providential if he were to die. Something like that. In other words, this chap felt very strongly about the act of the judge in writing, complaining about what he complained about in his original contribution. Now, what this Chief Justice did was slap a notice of contempt against the writer of that letter. And so this is contempt of court. And the question then was, should the person who wrote that letter be punished for contempt? There is no doubt that the criticism was very tough, very harsh. And the case went up to the Privy Council, which is the highest court for appeals from certain colonies. The Privy Council used to be the highest court of appeal even for India, but that was many decades ago. For certain Caribbean countries, the Privy Council still remains the highest court of appeal. So the case went to the Privy Council, and the Privy Council ruled emphatically that the Chief Justice was completely wrong in slapping a case of contempt, because he had no business in the first place to write articles in newspapers. That's not part of his job. As a judge, you don't write things in newspapers, particularly about matters not connected with your work. And secondly, if he felt aggrieved about what this writer had written, he can always file a case for defamation. In other words, if he had been defamed by the letter, there's no difficulty. Go and file a case of defamation and you might win. But why do you slap a case of contempt against the writer? Because by doing so, you are misusing the law of contempt and you are chilling freedom of expression. And this is an old case, 1893. So it's a salutary principle that was laid down in that particular case. And it is a principle which needs to be followed even today. Now, that's what the case was all about. I want to talk about this case, which happened very recently in India, in the state of Kerala. The facts of the case were as follows. P.D. Rajan is a judge of the Kerala High Court. On one occasion, I think it was on a weekend, he went from the place where his High Court is situated, which is Kochi, to another town in Kerala, where a festival was taking place. So he went to a temple where there was a festival going on, and he was in civilian clothes. When he was at that place, he had parked his car and he was sitting in his car. And from his car, he summoned 2 police constables who were in the area. He said, "Come over here." So the constables went to where he was, and he told the constables something like, "Can you please go to the clinic?" He showed where the clinic was, just over there, and tell the doctor in the clinic to come to my car, or tell the doctor that I'm waiting in my car, or something like that. Now, these 2 cops had no idea who this fellow was, and they naturally were a bit surprised at this, even if you want to call it politely a request. It was actually not so much a request as a command. Anyway, so what the cops did was, with reasonable politeness, the cops asked the the judge, without knowing he's a judge, asked him, could he not himself go and tell the doctor what needed to be told? Because remember, it's not part of a policeman's duty to carry private messages of individuals. They didn't say that. They very politely said that. And what they also did was address this fellow as, in Malayalam, Cheta, which is elder brother. A bit like, I suppose, in Calcutta you call someone Dada. So that's what they said. And this man got extremely angry. And he said, "Do as I ask you to do, and go and tell the doctor what I told you to say." I think the policeman at that stage said, "Very sorry, sir, but we are unable to do that," or something to that effect. Again, they were very, very polite. And the next thing that happened was, this happened, as I said, on a weekend. And on the Monday morning, the cops got a notice from the High Court slapping them with a charge of contempt and asking them to appear before the judge at 11 o'clock or something like that morning. And of course, the notice was sent to the cops' boss, whoever they were, Deputy Commissioner of Police or whatever. The cops had to go because this was an order from the High Court. So they went to the High Court and they saw the same chap sitting on the bench there. But they didn't know that he was a High Court judge. Earlier when they encountered him, of course this time he was in his robes. And he was very arrogant. And he said, "Now, do you know what you did to me 3 days ago? You disobeyed the order of a judge, and I'm going to punish you for contempt." Just imagine. And he said, "Do you have anything to say?" And they, poor souls, must have mumbled something about saying, "Very sorry, we didn't recognize you as a judge, and in any case, we were polite to you," etc., etc. Remember, these cops did not have any lawyers representing them. They just came because they were asked to come. And so the judge said very arrogantly again, "No, what you did was totally wrong, totally unacceptable. I'm sure you'd have added a few more words." And said, "You know what, I'm now going to punish you. Go to the corner of my courtroom, stand there, and write an imposition." He said, "Copy down the chapter from the Police Act of Kerala, which deals with the duties of a police officer." So there's a chapter there. You write it down till the court rises today, 4 p.m. or whatever it was. Now these poor fellows, they had no choice, so they went and wrote the imposition. Now, The pity is that nobody came to their rescue. And I must confess, when I first read this item in the newspaper, my blood boiled, because I think this is exactly the sort of arrogance which brings the judiciary into disrepute. Normally the law of contempt is used to prevent the judiciary from coming into disrepute. But here's a man who has done everything possible to bring the judiciary into disrepute. Unfortunately, there is no support given to these two cops. All that happened here was this judge was trying to assert his ego, nothing more. And he was needlessly being vindictive to two people who were very weak. You know how it is in India, if you're a police constable, nobody will come to your aid. Even your bosses will disown you for most of the time. And unfortunately also, what this judge did was, he passed a judicial order about this punishment. Now, one of the rules, this may sound very technical to you, but one of the rules about the judiciary is that when a judge passes a judicial order, it can only be challenged in another court. It cannot be struck down by, for example, the Chief Justice or someone else, because it's a judicial order. It has to be properly judicially removed. And so the solution would be either for the courts to go in appeal to a higher court, a division bench of the Kerala High Court, or for the Attorney General, the Advocate General of Kerala to bring an application for the order to be struck down. I don't think the cops had the resources or the support to challenge this court in another court, challenge this order in another court. And the Attorney General, I don't think, was minded to help them in any way. I did write to an MP in Kerala, a personal friend, and said, look, can you do something about it? And he said, I'll try, but I'm not sure if I'll succeed. So all that happened was these two poor cops did undergo this punishment, and they are still, I'm sure, reeling under the effects of it. They did not get any relief, whereas the judge continues merrily to sit on the bench. This is an example of a gross abuse of the contempt power. You may, if you're interested, find details of this case by just going to the internet. If you Google PD Rajan contempt police constables or something like that, you'll be able to get further details. So the point I'm trying to make is the law of contempt should never be used for this purpose. It was not intended to be used for that purpose. Yeah.
Was the conduct of a judge outside courtroom, will that be treated like an ordinary man? Like, to be very practical, we also know of cases where judges were building their houses, call up the OC of the police station and ask a sub-inspector and two constables to be posted, and the work goes on. So when a reporter, when a journalist writes about this, will this amount to contempt of court, or it will be just an ordinary person?
It should not amount to contempt of court, because what he is doing is outside his powers. That is the point I'm trying to make. So, even in this case, there will be no difficulty in setting aside this fellow's order. In fact, if only somebody had taken this case to a higher court, not only will the order be set aside, but the judge concerned will have serious strictures passed against him, and the two constables would have been paid compensation for the agony they had to undergo. But the pity is nobody is taking up the case. If the case is not taken up, what do you do? And this fellow is sitting merrily. That is a problem.
So I don't get this point. So you say that the judge cannot be a judge in his own matter. But so when does this principle apply? Like, does this apply in appeal or?
No, this is a violation. Absolutely. You're quite right. This judge, even if it was a contempt case, first of all, it's not a contempt case. Even if it was a contempt case, should not have heard the case. There are so many violations here. But violations can only be rectified if they're challenged. And this action has not been challenged. Now it's too late. It's almost 2 years since this happened. So the point is simply, as I said, that the law of contempt was never intended to be used to vindicate the ego of a judge. But it happens all the time. It's such a pity that these things go unpunished or even unnoticed to a certain extent. So that's what the case was all about. Now, there was one other case which was rather similar. This was a case from Allahabad, and the judge was a man called Kudusi. Now, this was rather amusing at one level, but also equally depressing. This fellow apparently had been denied a railway berth. So he was traveling from somewhere to somewhere, and when he went up to board his train, he asked for his sleeper, and he was told, "Sorry, but your name is not on the list, so you don't have a sleeper." At which point he apparently held court on the platform of the railway station and immediately passed orders against the assistant station master, deputy station master, and said, "I charge you with contempt, I convict you of contempt," etc., etc. Now, there was a public interest litigation filed by somebody, some outsider, but the case was withdrawn after a statement which was made by amicus curiae appointed for this purpose, that the matter had been dealt with administratively. Difficult to make out what was done. All you get is this bland phrase, "matter was dealt with administratively." It is not satisfactory, because I personally think examples of this kind should be properly investigated and publicized. So, for example, what is the action taken against the judge if he had acted wrongly in filing a case of contempt against the deputy station master? Now, there is a little addition I can make to this story, because I took the trouble some years ago of phoning this judge and asking him whether what was reported was true. And he told me, "No, it's not true. I'll tell you why, because actually the fellow who was dealing with me at the railway station was drunk. He was misbehaving with me. Secondly, that it was not a case of me simply asking for a berth. It is that, first of all, a request had been made for a berth for me, and secondly, I was on judicial duties at that time. In other words, I was traveling on work, not in a private capacity. And in those circumstances, I took the decision I took." This was his version. No, he may be right, because I also know that unfortunately the media don't always report things properly. So it's possible that he had a point. But then something else happened afterwards which made me wonder, and that is, unconnected with all this, I saw an item on YouTube which was a sting operation against this judge for corruption. So I leave it there for you to decide what is credible and what is not. Okay, Carmen. Now, this is of course a case which has excited a lot of interest, and I do not want to go into the details of what happened to Carmen, because that's not relevant to what we're talking about. That's not a matter falling within contempt. Although of course he disobeyed orders, that is contempt, but that is not relevant to the media. What is relevant to the media is an order by the Supreme Court in the middle of all these proceedings and the circus that accompanied the Carmen case, not to report any statements from the judge who had been found guilty of contempt. Now that I find quite extraordinary. It is true that many of the things that happened were unsavory, and they did not show the judiciary an impressive light. But to ban the media from reporting anything that the judge said, I think is wrong, because there is a principle involved here, and that is to do with freedom of the press. So why do you stop the media from reporting? What you could have done is stop the judge from making those extravagant statements, or from holding court in his home, etc., etc. But to stop the media, I'm not sure. I think it is a wrong precedent that the Supreme Court has set. So we leave it there.
So, but given how Justice Kannan has a history of not caring very openly about what the senior judges have to say, don't you think that, say, imposing a gag order on Justice Kannan would have been a futile idea, because he was anyway not going to follow that, which means that no matter what order you imposed on him, he was still going to say what he wished to say against his brother judges, right? And in that case, don't you think this order the order of the Supreme Court here to ban the press from reporting any statements can be argued, say, as a ground of public order, I mean, to ensure that there isn't any, there isn't any more damaging and more damage caused to the judiciary and the views of the judiciary.
Okay, you used the phrase public order. I began to think at that point, you were thinking along the lines of if Kannan said something and that resulted in more violence. Is that what you have in mind?
I maybe started to think that when I realized that going by the history of what Kannan has said, I don't think that would have been possible.
Right.
Because the views he had were largely, I mean, I don't think they were sufficiently scaling to incite violence. But say, would you argue it as could you argue are there any of the reasonable restrictions to restrict the freedom of the press?
I think it is an unreasonable restriction on the press. I totally agree with you if this is what you're saying, that what Kannan began to say amounted to dirty linen being washed in public about the judiciary. I totally agree. But the way to deal with it is not by gagging the press. That is the point I'm making. Because in a democracy, even if you are crackpots like Kannan, they have the media have a right to report because it's a matter of public interest. If anything, you are sort of exposing to the public the nature of some of the high court judges this country has. That, to my mind, is a very serious matter. Who in the first place allowed such a person to become a high court judge? It's a very troubling question, and those questions have to be put before the public. That is the point I'm trying to make. And in those circumstances, you could have limited the damage by doing something to Kannan, but not to the media. That is the point I'm trying to make. Because he has every right, or let me put it the other way around. The media have every right to report on matters like this, as long as it's not defamatory, as long as it's not incitement to violence, and etc. etc. The media is just doing its job. So in those circumstances, I think it is wrong to gag the media.
How far? I mean, to what extent can media go in case of covering cases like Justice B.D. Rajan case? Can media make an issue out of it?
Absolutely. I'm surprised that the media has not made an issue out of it. And maybe even at this late stage, somebody here wants to write an article. I would strongly encourage you to do so, because I don't think many people in India have understood that such a thing happened at all. Very limited circulation, as far as I know, the newspaper reports that appear. Most of them appear in South India. I don't think the news has actually travelled to the north. You should actually write and let the fellow be shamed, and that would be entirely legitimate criticism, as long as you use sober language in criticizing him. However strongly you feel about it, I think it's possible actually to bring out the inequity of what happened without engaging in extravagant language. So it's definitely worth it. And it's not the only one. There have been a number of cases, as we'll discover when I talk about other cases as well. But this was a particularly egregious case of a judge misbehaving. Anything else? Okay, if not, let's move on. Now, I'm just giving you a general principle which has come out of a judgment, which needs to be kept in mind at all times. And that is that no criticism of a judgment, however vigorous, can amount to contempt of court, providing it keeps within the limits of reasonable courtesy and good faith. This is the point which, in a sense, goes back to what I said at the beginning of this lecture, that criticism of judgments is entirely permissible as long as there is a degree of reasonableness and courtesy. And of course, there's another principle which is important, and that is that the names of judges or magistrates should never be kept secret. You cannot, in any free society, have a situation where a judge says, you report whatever is happening in my court, but please don't report my name. Totally unacceptable, completely unacceptable, because this is a fundamental principle of law. You can even report the name of a judge where the hearing is closed to the public. No problems, because justice, open justice means that the judicial personnel always have to be identified. The only possible legitimate reason why a judge would not want his name to be publicized is a fear of personal attack physical attack. Now that is dealt with by the fact that judges are provided with security. That if you want to become a judge, you always have to accept the fact that there is a small element of risk, but that risk is covered by the fact that you're provided with adequate security. Where reporting restrictions are imposed, and this should be made clear so that the media are not kept guessing or in the dark. This also doesn't happen all the time. A court, when it imposes a reporting restriction, has a duty, first of all, to record that restriction in writing. These oral restrictions are usually very wrong. Secondly, having recorded it in writing, those restrictions should be publicized. Now, how you do it, you can have a debate. In the old days, publicity used to be by pasting a copy of the report outside the courtroom. Nowadays, with the internet, it's very easy, at least put it on the website. I would suggest that good practice would mean that the courts have a regular arrangement with court reporters. I would go to the extent of talking to press clubs, whereby they send automatically copies of these kinds of restriction orders to the press clubs and association of journalists, so that their members are constantly kept informed. And that is arrangement in many countries. So again, something that the Indian judiciary can learn.
Sir, there is a reporting restrictions ruling by Supreme Court in Sahara case, where the Supreme Court given a judgment that if one of the litigant, the aggrieved party, can plead to the trial court and for a specific period, there could be reporting restrictions, but it has to be case by case and could be given by the trial court himself.
Yes, but that order, I presume, has been made public. Yeah, so that's a good thing, which means that journalists are alerted to the fact that there is a reporting restriction. Absolutely. Look, reporting restrictions are not bad. There are reasons why reporting restrictions need to be made. No problems with that. But when you make them, at least allow people to know about them. That is important, particularly journalists, because if you don't know about reporting restriction, there is a risk that you may accidentally fall foul of the law of contempt. You may go ahead and publish something which is the subject of reporting restrictions. So a good practice means that there are ways through which journalists are alerted to these reporting restrictions. Any other questions? I think we should wind up because we have just passed the 12:30 deadline. Yes?
Sometimes judges make comments during the trial or during the hearing. So how far is right to report on the comments?
According to me, there is no restriction at all, if you're covering the trial, to publish comments made by a judge. Unless a judge, for good reason, says certain comments should not be published. So you have to look out for that. Otherwise, there should be no problems at all. Okay, yeah?
So I would like to bring to your attention one particular thing which you must have heard that it came up during our discussion today. The journalists are protected from disclosing the source, whether it's a myth or how far it is legally maintainable.
I'm going to talk about that tomorrow.
Okay.
It is part of contempt of court. Okay? I'll talk about that tomorrow. Okay, so if there's nothing else, we'll stop here and I'll expect to see you once again. I'm beginning to feel that this is a futile request, but I still want to make the request. Can you please come 5 minutes early? Come at 10:25, please. Thank you.
Sir,